I've been involved in domestic violence cases, defending a victim where the husband says you're a effing B, right, in front of the kids. And under our statute, that is domestic violence. You would agree with me?
Yes.
What, I don't, okay, so that is, I mean, DCF gets involved and all that stuff. That is, and I think it's correct that, we shouldn't be saying that bad stuff in front of the kids, because kids learn from their parents, and hopefully they learn well from their parents. And then, unfortunately, what we learn is that kids, as they get older, emulate their parents, right? So dad saying that to mom in front of the children, more than likely that child is going to determine that that's appropriate conduct and may do that bad conduct as they grow up. So public policy-wise, we've said that those kinds of things are bad, and that's domestic violence. So I'm trying to figure out if the domestic violence is merely verbal, why it would make sense for a judge, their discretion to be taken away on a sentencing. Because this is a mandate. This is, the law says, so somebody is convicted of shooting up a school, let's say. 20 people are dead. And at sentencing, ordinarily the sentence would be life without possibility of parole. That then they could assert that they were a victim of domestic violence, and perhaps language like that, and why it's good public policy that the discretion of the judge on sentencing would be removed.
That's an interesting example to choose. I would say that the discretion is not being taken away from the judge. I would say that the discretion is actually being improved for decision makers. And by doing that, they are able to take the different circumstances into consideration, including the types of crime and the circumstances surrounding abuse related to the
So are you aware how our
survivors.
courts sentence presently?
I'm not a lawyer, no. So,
Okay, so you've never been to court, you've never seen somebody sentenced on one of these cases?
I mean, I've been to court. I used to be a victim advocate. Unfortunately, it was during COVID, so a lot of the things were remote, but I
Okay.
witnessed it.
Well, when you said it doesn't take away the discretion, I'm looking in particular at line 87 of the bill, and it says the court shall depart from the applicable sentence subsections. So that's a mandate. That says the court has to do something. So I don't know, you were saying it doesn't take away discretion. I'm trying to figure out what the basis of the representation is.
I would maybe defer that question to one of the other experts within the coalition, only because I'm testifying on behalf of the coalition, but I'm not leading it, so I am not as much of an expert on this particular policy as the other leaders in the coalition.
Okay, so then what about the timing? It appears to me that if one is sentenced, and they've asserted this, and the court denies the application, it's without prejudice, meaning that they can refile. Why would we have, because at the other end of these cases, there's victims, right? So now somebody is convicted, mass shooting, let's say, and the court rejects the domestic violence claim under the statute, sentences them for life without parole. They've lost that. It appears to me that they could turn around the next week and then reassert that. Why is that good public policy?
Well, I believe there's other time considerations within the bill, but I will repeat my previous response, which I would ask that you refer that question to one of the leaders within the coalition.
Are you aware of I'm sure as a victim's advocate, pre-sentencing reports, you've seen those, been aware of those?
I'm not sure, to be honest. I was dealing primarily with contacting victims after the police reports were filed.